After the presidential election in the United States, a massive migration wave started, and migrants with doubtful documents headed mostly for the so-called 49th parallel, which is the borderline between United States and Canada. Also, another well-known crossing point is between New York State and Quebec. You might ask yourself, what caused this migration from the United States to Canada? First of all, those so-called refugees from the United States were illegally there since their visa expired or was rejected. Secondly, the Canadian Prime Minister Justin Trudeau made an open invitation to illegals from the USA. His statement said that regardless of your status, you are welcome to Canada. Needless to say, this opened the Canadian borders to the illegal migrants. This became a serious issue for Canada. The federal government explained this by saying that there is a so-called loophole in the international agreements, a discrepancy between the Geneva Convention from 1951 regarding the status of refugees and the Third Country Agreement with the United States. Well, my Canadian friends, I took my time and checked out the Geneva Agreement regarding the refugees, and I have to admit that the Canadian government, probably for political reasons, misleading the Canadian society. There is no such a thing loophole in any international agreement Canada is a signatory of or Canadian immigration law. We all know what the Third Country Agreement means. If you are a refugee in the USA, you cannot cross illegally the border to Canada because you will be returned. This means that right now the Canadian government breaks its own immigration laws and international treaties and allows illegal migrants into Canada. Here is the articles from the Geneva Agreement regarding refugees. Convention and Protocol relating to the status of refugees. Text of the 1951 Convention. Relating to the status of refugees. Text of the 1967 Protocol. Relating to the status of refugees. Resolution 2198, XXI, adopted by the United Nations General Assembly with an introductory note. By the Office of the United Nations High Commissioner for Refugees. Article 31. Refugees unlawfully in the country of refugee. 1. The contracting states shall not impose penalties, on account of their illegal entry or presence, on refugees who, coming directly from a territory where their life or freedom was threatened in the sense of Article 1, enter or are present in their territory without authorization, provided they present themselves without delay to the authorities and show good cause for their illegal entry or presence. 2. The contracting states shall not apply to the movements of such refugees restrictions other than those which are necessary, and such restrictions shall only be applied until their status in the country is regularized or they obtain admission into another country. The contracting states shall allow such refugees a reasonable period and all the necessary facilities to obtain admission into another country. Article 32. Expulsion. 1. The contracting states shall not expel a refugee lawfully in their territory, save on grounds of national security or public order. 2. The expulsion of such a refugee shall be only in pursuance of a decision reached in accordance with due process of law, except where compelling reasons of national security otherwise require. The refugee shall be allowed to submit evidence to clear himself, and to appeal to and be represented for the purpose before competent authority or a person or persons specially designated by the competent authority. 3. The contracting states shall allow such a refugee a reasonable period within which to seek legal admission into another country. The contracting states reserve the right to apply during that period such internal measures as they may deem necessary. Article 33. Prohibition of expulsion or return, refoulement. 1. No contracting state shall expel or return, refouler, a refugee in any manner whatsoever to the frontiers of territories where his life or freedom would be threatened on account of his race, religion, nationality, membership of a particular social group or political opinion. 2. The benefit of the present provision may not, however, be claimed by A refugee whom there are reasonable grounds for regarding as a danger to the security of the country in which he is, or who, having been convicted by a final judgment of a particularly serious crime, constitutes a danger to the community of that country. I will read the Article 31 paragraph 1 again, listen carefully. Article 31. Refugees unlawfully in the country of refugee. 1. The contracting states shall not impose penalties, on account of their illegal entry or presence, on refugees who, coming directly from a territory where their life or freedom was threatened. This means all those refugees who are crossing illegally the USA border to Canada should be returned to the USA. This is not happening because for political reasons the Canadian government breaks its own law, misinforming the society.